What Jukua did was to energize the police, the chiefs, and everybody to take the rightful position at the Court Users Committee. And there they will be asking, why are things not working? So thank you very much for that, because that brought out the need for a complete Marshall Plan for the justice sector. We called you, our CS, as a special guest because we recognized what you did in Jukua ya Usalama. We always do it as the judiciary. You remember in January we had the Judiciary Dialogue Day. And at the Court Users Committee, we are always trying to bring everybody together. But what Jukua did was to energize the police, the chiefs, and everybody to take the rightful position at the Court Users Committee. And there they will be asking, why are things not working? So thank you very much for that, because that brought out the need for a complete Marshall Plan for the justice sector. It is an expensive venture for us to build those police stations, to build those courts. The other day, a young judicial officer was giving us our own experience of going to work in those courts where we do not have an infrastructure, and she has to walk with her high heels to a pit latrine with her tight skirt and her high heels. So, I mean, it's the same. So we need this infrastructure, both for the police stations, for our prisons, and for our courts.
We ended our national-wide security and service delivery dialogues, known as Jukua la Usalama, to make just three. I just want to make very, very few remarks or lessons that we learned from this process. Number one is that we cannot survive or operate in isolation. We cannot continue protecting our turf. In fact, Chief Justice, I think we need to amend, even though the Attorney General said that we have too many laws. We need to amend the National Council, the Principal Act, which is the Judiciary, what's it called? Judicial Service Act, yes. The Judicial Service Act, Section 37, or prior sections, I think 35. We need to, the court users committees need to be strengthened. I realized from the Jukua la Usalama that some of the problems that are bedeviling the nation is because at the county level, and I dare say even at the sub-county level, there is a very poor interaction between the security, the sub-county security team or county security team, the judiciary, and the DPP. And sometimes the back and forth is because the DCI officer who is doing the investigations, there's a DPP sitting somewhere waiting for the file, and then, you know, there is no interaction, there is no conversation. Then the matter is called to court, and because there is no general conversation around with the magistrates, there is a dysfunctional system in the county. But I found it very interesting in a place, for example, in Vihiga, where people are praising the magistrate, that we are working together with the magistrate and we've been able to reduce cases of gender-based violence, especially defilement in that particular place. And in some areas where the court users committees are working, the delivery of justice is really wonderful. Part of the reasons why people are refusing to work together, you will shock you. You will find in our ministry, the chiefs are supposed to work with the OCS, but they refuse to work together. And we found in one of the counties, I think it was Kakamega, in a place in Butere, that the chief says the real reason why they're not working together is not because of even their big persons, no. Because you work in silos so that you collect your bribe independently, you know? So if they end up working together, you know, so everybody's saying, I'm the one who is in control. You know, I'm the one who's in control. If the police officer, the OCS is telling the chief, telling the brewer of the illicit, whatever, changa and so forth, illicit alcohol, he's telling them, don't worry, that chief has no powers. Wewe tu akushike, akulete hapa, I will release you, you know? Because he knows, so he's telling this one, don't pay the chief. Just pay me, I will allow the chief to bring you here, I will release you, you will go. We also found in some cases that it is the DPP wants the DCI to continue struggling at the corner there on his own, and then when he brings the file, because the DPP officer at that level has been compromised, he will not approve prosecution. So no matter what the DCI has done, even if he has done a very good job, the DPP is not approving. Meanwhile, in some cases, the magistrate has already been compromised on the other end, even if a matter comes before court. So some of the reasons why people are not sitting together is because if they sit together, there will be greater accountability and corruption will be dealt with. And I think it is time we need to strengthen the court users committees and bring them together so that we can resolve problems that are affecting the people of Kenya. When the Judicial Service Act speaks of efficient and effectiveness, these are not just buzzwords. They mean delivering results quickly, meaning speedy investigations, prompt trials, and effective rehabilitation. This is because delayed justice is not just only frustrating, but also very dangerous. The rising cases of mob justice is basically as a result of frustrated population, that they want justice immediately and soon. And so it is very dangerous for law and order and for the well-being of the country. If they feel that justice system doesn't work, they become impatient. And then you see rising cases of mob justice across the country. In fact, I dare say some of the mob justice cases are actually encouraged by the police. You know, and I am admitting from a point of knowledge. Because the police will tell the citizens, you think you will get justice? This thing will drag in court for another 10 years. Tafuteni njia ingine bwana jiokoe. And njia ingine, they don't say it, but they are actually encouraging that if you can sort this matter, then it will be better. In fact, in most cases where people are arrested, taken to court, they are released, they are taken to court, they are released, there are high chances that the police actually will be probing the public to say, do something. And then they will come back and do investigations. And when you tell them, when will they, when you ask them what is the status of this matter, they say investigation is still ongoing. Which is the statement I read every time I go to Parliament, and the most repeated statement is investigations is still going on. So it's important to expedite processes of justice. Otherwise, you know, it can destabilize a country and it can lead to a disorderly nation. In the recent trip we did around the country to assess our performance in the Ministry of Interior National Administration, we called it Jukwaa la Usalama. I realized something very fundamental. The common citizen down there they really don't know what is the role of the police, which one is for judiciary, which one is for DPP, and which one is for the prisons. Prisons, at least, they fairly understand. But for the investigators, the prosecutor, and the judiciary, they confuse all of it, and they want government to serve them. In fact, they do not know. Sometimes when you arrest somebody and they are released the next day on bail, they quickly blame the police officer. They say the police officer is very corrupt. That person was released immediately, and that they must have paid a bribe. When they are presented before court and they are entitled to bail, for many of them, they think that as soon as someone is presented before court, today they will be incarcerated, and the rest of the decision, they are not entitled to any bail. So they will be remanded until the day they are convicted. And they wonder why this is being debated. So at the end of the day, when someone is taken to court and then they are released on bail and they come home, the first thing they do is that this government is corrupt. And they do not know the Chief Justice. They only know that the government of William Ruto is corrupt. It has nothing to do with the judge. It has nothing to do with the... So they know only one government and one country. And I think this is the reality. I mean, sometimes we are lawyers, we are, speaking a lot of good English in courts and in such fora, but the reality on the ground is that people do not know the so-called separation of powers. Important as it may be in terms of functioning, they know that we are one government, one country, that they expect justice from us. And therefore, this should really, really be a basis for all of us to come together. I am glad to see the NCAJ model bringing together everyone, including state institutions, the Law Society of Kenya, and civil society organizations. We need each other. We need LSK, we need civil society to challenge us and to remind us what we should do better. This should not be seen as an interference, but it's an opportunity for us to see as a high level of accountability in that country. This annual report shows us what we have accomplished and what we still need to work. But today's launch on the justice sector, monitoring, evaluation, and learning framework is equally important because it will help us measure something Kenya are deeply care about, the speed of justice in Kenya, the delivery of justice in Kenya. Let us be honest, Kenyans are impatient, and rightly so. When someone reports a crime, they want the action. When a case goes to court, they want it resolved. When someone serves their time in prison, they deserve a genuine chance at the rehabilitation and a new start of life. When cases drag for years, public confidence in the justice system is eroded. When the guilty walk free, communities generally feel abandoned, and when rehabilitation fails, then the cycle continues. I know we don't always agree. Sometimes the ministry questions why certain cases move slowly. Sometimes it's the courts that question why police take time to investigate a matter. Sometimes correctional services wonder why they don't get enough resources. But this is what I want to emphasize today. We need to strengthen our partnerships. A nation is not made peaceful by force alone, nor more laws alone, but by harmony between both. Security without accountability diminishes justice. Justice without security cannot flourish in any country. You can carry a court order actually around, and if you don't have enforcement mechanism and a secure nation to enforce a court order, then it can be a beautiful piece of paper without a proper secure nation that can actually turn that court order to become proper results. So we have cases where people have very good court orders about going back to their farms or, taking back their property and so forth. And if you don't have a proper, if you have gangs occupying somebody's land in Machakos, for example, or somewhere in Nandi or Kisumu, and you have a beautiful court order, and the police are unable to remove those gangs, and because of breaking of law and order, then it becomes very dangerous for a nation. And really, that is why I continue emphasizing. I wonder, there used to be a principle in first year law class, especially Constitutional Law 101, that a judge always is alive to the circumstance they face, and therefore they take what is called judicial notice. And it's assumed that judicial notice doesn't have to be brought up by any lawyer or a litigant in court. The judge should just be alive to the fact that, because we live in this society, if there is a flourishing of the many gangs in the country or people burning property, you don't need anyone to alert you to say that if you release this person back to the society, there is a fear that the particular situation will continue. So judicial notice is also very important. And it's also important to just know what's happening. around, you know. And you can only know that if we can talk. It doesn't have to influence your decision per se, but it helps you to make sure that you have a role beyond just making pronouncements. You have a role to ensure that the society is safe. I'm very happy to be here. I look forward to a stronger partnership between this ministry and yourselves, and let's work together. I think, as my last closing remarks, I think, and this is for our judges, I think a judge, and being a member of this profession, who is properly trained and sufficiently confident, doesn't fear even sitting with the president, doesn't fear sitting with that opposition leader, because they know that they are guided by the law when they make their decision. But this idea that if you see the Chief Justice sitting with the president or sitting with a leader of opposition, they are having a chat, you make an assumption that, they are already compromised. It's the very reason why people are closing themselves in different areas, because they fear that if they sit in a particular place, they will be compromised. That is the same reason why the president of the Law Society of Kenya ran away from this committee to solve problems, because as soon as her name came out, they say she's been compromised. We cry that we want justice for the victims, for people who are downtrodden. And when we pick people like the president of the Law Society of Kenya to come there and resolve those issues they have been criticizing government for, then we're criticizing them for being there to act. And I think it is unfortunate. We need to make sure that we are properly trained as lawyers to interact with anybody, including across the, a lawyer for the defendant and for the applicant are always taking tea together. And so why not? Why can judiciary and the executive and the legislature sit down and thrash out issues that will promote justice in our country? I thank you.